They can enhance your smile through the art of dentistry.
And it's 11:26 on this Monday morning, and it's now time for the Quatrini Law Group with offices in Uniontown and Somerset, as well as Greensburg. They specialize in personal injury, workers' compensation, social security disability, employment law, long-term disability, and veterans benefits. You can call 888-534-6016. That's 888-534-6016. And our guests today are Ernie Orsetti and Casey Seaman. Both of you, welcome today.
Thank you.
Thank you.
Go ahead, take it away.
Well, I've been representing labor unions for over 50 years, and we also represent employees in employment matters. And the thing about representing employees is that we've got the worst employment laws in the world. The United States favors employers tremendously. The laws in Europe, Canada, and even Mexico give employees much better protections than we do. And we get calls almost on a daily basis from employees who are shocked to find out that they don't have the rights that they thought they had. And they call us with these horror stories about what their employers have done to them. And we have to tell them, when they tell us that they're not represented by a union and they don't have employment contracts, that the employer has the right to do that. Employers have the right to terminate their employment for a good reason, bad reason, or no reason at all, as long as it doesn't violate a specific discrimination law. And the problem with that is that the employee has the burden of proving that the employer's motivation in terminating them is because they're a member of a protected class, such as age, sex, race, disability, or because they were attempting to organize a union. And that's the problem, is proving motivation, because most employers have become very sophisticated in hiding their motivation. So that makes it difficult for us if we try to represent an employee who's been actually discriminated against for one of these reasons, because it's our burden of proof. The employee has to prove that was the motivation. So they usually come up with some other false reasons for why they've been terminated.
Yeah. Yeah, the biggest thing to think about here in Pennsylvania is that employees are at will if you're not in a labor union. So being an at will employee, like Ernie said, they can terminate you for pretty much any reason. I always like to joke that they can terminate you because they don't like the socks that you're wearing that day. But joining a labor union allows you to come out of the at will employee category.
Yeah, and they don't even have to tell you why they're terminating you. They can just say you're fired, and we don't have to tell you why. And the other thing is, employees are under the false impression that they're entitled to vacations, they're entitled to health care plans, they're entitled to other types of fringe benefits that people expect employees to give them, but they're not. Those are things that many employers will voluntarily give them, but they're not required to. And they can change those benefits at will. They can do it, and they can give some employees benefits and not others.
Yeah, exactly. So I know in Pennsylvania, there might be employee handbooks that control whether or not you would get your vacation payout when you're terminated, but that's not something they legally have to give you necessarily. It's always the policy that controls, and it's up to the employer at the end of the day whether or not they want to honor those policies and enforce them. However, when you're in a labor union, you get the benefit of having a collective bargaining agreement that normally sets out those benefits, and they're bargained for between the employer and the employees, and that's something that you don't get when you're not in a union.
Yeah, and that brings up another point. And employees do have control over whether or not they're covered by a collective bargaining agreement. They can decide, and the bottom line is that they make that decision, not the employer. Despite what employers may tell them, and they have that right. They can choose to become a member of a union, or they can decide to become their own union. They can form their own union, and I've done that myself over the years. And it's not that hard. The creation of a union is a very simple matter. If employees in a particular bargaining unit, whether they're public employees or employed by a private company, as long as there are at least 2 employees, they can form a union. And all they have to do is decide that they want to become unionized and create their own union. And all it's involved is making that decision and getting a majority of that group to become dedicated to that purpose. And if they become committed to becoming a union, it's not that hard. And what I've done, and I've had groups come to me, and I counsel them, and the advice I give them is: do you want to become an independent, self-sufficient union, or do you want to join an established, either a small union or a union that's affiliated with a larger union? And then I can guide them in that direction. I represent a large number of labor unions, and I can guide them and advise them as to what the best union for their purpose would be. And then I can introduce them to a union representative who can walk them through the process, and I could represent the union and help them do it. But in the case where a group decides they want to form their own independent union, the first thing to do is I would advise them to select a group of officers to represent themselves, because unions are democratic organizations. Unlike corporations that are top-down organizations, unions are bottom-up organizations. They control their constitution and bylaws. They elect their officers, and they decide what kind of due structures they have. So the first thing I do is I advise a union or a group of employees to decide for themselves what kind of constitution and bylaws, and we write up a constitution. They draft their own constitution, like the founding fathers of the United States. You sit down and you decide your own constitution and bylaws, the rules that they live by. And the law requires unions to follow their own constitution and bylaws. That's the law requires them to do that. So they have to be very careful in making sure that these are laws that they're willing to abide by. That's the first thing. Then they have to elect officers who will run the union. And if they're in the private sector, in other words, they're not public employees, but in the public sector, in the private sector, they have to have elections every 3 years for officers. So they elect a group who will run the union, an executive board, and it's usually a president, vice president, secretary, treasurer, and recording secretary, and trustees who run the union and are responsible for the day-to-day operation of the union. And they can still work for the company. And then decide how they're going to finance the union, through a due structure, so they pay themselves to run the union. And of course, there are a lot of laws that apply to how the union is run.
Yeah. And another important thing to note with that is that that's a protected activity. We see a lot of employers try to interfere with that process every day. Forming a union at most employers is an employer's worst nightmare. Being a union force at an employer, you have more rights that aren't typically, given to a normal employee, and the employer will have to, follow that CBA if they have a union force, and I guess there's a little bit of a wrench in their schemes, but that right is protected by the National Labor Relations Act. And if for some reason your employer is interfering with that process, either terminating individuals who are trying to form a union or speaking about unionization, you can file a charge with the National Labor Relations Board.
Right, and there's a similar statute for public employees. Mm-hmm. It's called the Pennsylvania Public Employee Relations Act, and it's similar to the National Labor Relations Act, and it protects public employees. And just like Casey said, if an employer attempts to interfere with that right in any way whatsoever, unfair labor practice charges can be filed with the Pennsylvania Labor Relations Board if it's a public employee, and with the National Labor Relations Board, as Casey said, if they interfere, if you're a private employer that does it. Mm-hmm. And this often happens.
All the time. And it's not just even forming a union, it's other things are included, such as things like discussing your wages. You have to be able to do that within your employment, and that's something that many employers will try to contract out in their employee handbooks, but you're allowed to do that, and they can't interfere with that process either.
Exactly. Now, once you've gone to this point where you've decided, if employees decide they want to form a union, and they've gone through the steps of creating their constitution and bylaws, appointing their union officers, and it's a majority of the people in this bargaining unit that want to do this. The next step is, well, how do we what's the next step? How do we become recognized as a formal union? Well, the next step is we would file a petition. If it's a private employer, we go to the National Labor Relations Board and file a petition for certification. If it's a public employee, if you're with a municipality, or if it's a state employee, we file it with the Pennsylvania Labor Relations Board. You file a petition for certification. Once we do that, then the National Labor Relations Board or the Pennsylvania Labor Relations Board, in the case of a public employee, will schedule an election, and the employees will make that decision. A vote is taken. It's a secret ballot election, and the agents for the various government agency will conduct this secret ballot election, and if the union gets more than 50% of the vote of the votes cast in either election, the union becomes certified as the exclusive bargaining agent for that group of employees. That becomes final and binding. And then once that happens, then the boards, the national board or the state board, issues an order requiring the employer to begin bargaining with the union. Mm-hmm. Now, I left out one point. What I always do with my union clients, or with my independent union clients, is before I file the petition, I make sure that I have signed cards from more than 50% of the bargaining unit before I file the petition. And it's important to do that, because what I do is, before I file the petition, I notify the employer that my client represents a majority of the members of the bargaining unit, And the reason for that is if the employer commits unfair labor practices before the election, because there's a campaign period between the time the petition is filed and the time of the election. If the employer commits unfair labor practices, which causes the union to lose the election, then if I'm able to prove that the employer committed these unfair labor practices by filing a charge after the election, then the boards can issue what's called a bargaining order, forcing them to bargain with the union. So that's why it's important to make that demand.
Yeah.
Right, this is kind of complicated, but that's why it's important for employees who are considering filing or becoming a union to consult with an attorney.
Yeah, absolutely. And once they are unionized, and they have a collective bargaining agreement in place and they're going through that process, that allows employees to have more rights when things come up at work. For example, if a company's not, filing or not following the collective bargaining agreement, or somebody is terminated, and to our belief and to the union's belief without cause, they can go through the grievance process and eventually go to arbitration. And through the arbitration process, we get the opportunity to present a case in like a typical, it's more of an informal court proceeding, but it's similar where we get to, question witnesses and put on a case and, explain why there wasn't cause for termination or why a provision of the collective bargaining agreement isn't being followed to the extent we believe it should be. And that's something that, regular employees don't get that opportunity when things like that come up at work. You don't have control over whether or not you're going to be terminated. You don't get a second chance to plead your case a lot of the time, and you don't get to, bring a company to an arbitration because they're not following their own handbook or something like that. So it's really important that you have a collective bargaining agreement in place if you want to have those rights at work and you want more protection for your job, especially in today's world.
That's an important point that Casey just made. Once a union becomes certified, the next step is that we negotiate a collective bargaining agreement with the employer. And that's an important process because once we negotiate a collective bargaining agreement, it's the employees who make that decision. The union bargaining committee, which, if let's just say we have an independent union, this is people that were elected by the bargaining unit members. The employees elect that bargaining committee. If they have an attorney, then that attorney can assist with the bargaining. If they decide to join an established union, then you have experienced negotiators that will sit down with the employer and bargain with that union. And as Casey said, they negotiate a collective bargaining agreement which contains all these benefits, the fringe benefits, vacations, health care, pensions, and that's one of the most important things that unions have negotiated for employees, pension rights. And probably the most important thing that every collective bargaining agreement that I've ever seen, and they all have, every collective bargaining agreement has what's called a just cause provision, which means that the employer cannot fire employees without just cause for termination. And that is the most important provision in that contract. That says that the employer cannot fire an employee without just cause. They're not at-will employees anymore. They have job protection. They can go to work without fear of being fired because their socks don't match or because their hair is red. They can only be fired for good reasons. And they have to prove those reasons. Because if they're fired and they file a grievance, the union can take that grievance to arbitration. As Casey said, that case goes to an impartial third party who's an arbitrator, and the union presents this case, and the employer has the burden of proving. The employer has the burden of proving that they had just cause for termination. Unlike a discrimination case where the employee has to prove what was inside the employer's brain when they terminated the employer has the burden of proving that there was just cause for termination, and the union defends that case. And we win most of these cases when we go to arbitration. So the employer is usually reluctant to terminate employees. It's not that they can't fire bad employees. They can. But they can't fire employees without a good reason. Unions oftentimes get a bad rap for protecting bad employees. We don't. We don't take bad cases to arbitration. We only take the good cases when an employee gets wrongfully terminated.
Yeah.
But the other thing that collective bargaining agreements have is a no-strike clause. We can't strike during the life of that contract. We get that in exchange for that grievance procedure that results in binding arbitration. Now, there are some employees that don't have the right to strike, like police and fire employees. They can't strike. But instead of that right to strike, they have what's called binding interest arbitration, where if they bargain for a contract and don't reach an agreement, and they reach impasse at the bargaining table, then they go to a 3-member board of arbitration, and one selected by the union, one selected by the employer, and a neutral arbitrator. And they receive evidence regarding the bargaining, and that panel makes the decision. And there were also prison guards don't have the right to strike, and court-related employees don't have the right to strike. They had also the right to go to binding interest arbitration.
Yeah, and binding interest arbitration, it will prevent going on strike, but at the same time, it also, you get, like Ernie said, 3 arbitrators who will help make the decisions over what policies should be included in the CBA, what's the reason for those policies, and what's going to, benefit both parties to what they believe is, fair, and that's basically it. And it prevents, major employees from going on strikes, which, helps the public out, but it also gives them, a fair playing field to make sure their grievances are heard about what they believe should be included, and, everyone is happy when it comes to at least ensuring that their rights are heard.
Or at least equally unhappy.
Or equally unhappy.
Because nobody is completely happy when you go to interest arbitration, because the Board of Arbitration tries to address the issues of both parties and come up with a compromise solution. But it's a fair system.
Exactly.
Because it's designed to deal with both parties' issues, and it normally does come around. And when I say equally unhappy, I'm being a little facetious, because when you go to interest arbitration, only the really difficult issues are the ones that are presented, because usually the parties resolve most of the issues before getting to that point. So it's a very good system. It really works out well.
It does.
But going back to the point I made in the beginning about how our labor laws are so unfair in the United States, they really are. But there is a solution to that, and I've been doing this for a very long time, and I really believe in what I do, because the labor movement has provided a solution to that problem. And that is, it gives workers an avenue to make life better for themselves. And many employers, and I talk to employers, are really proud of themselves, because they said, I'm a non-union employer because I pay my employees well, and I do this, and I treat my employees well. And they say this in a way to try to make me feel bad about the fact that they're non-union. And I praise them. I say, you know what, I think that's great. And you should not have a union because you're doing the right thing. And they look at me like I'm crazy. But not every employer needs a union. If you're doing well, if you're treating your employees properly, and you're paying them the equivalent of a union wage, and you're giving good benefits, and you're treating your employees well, then your employees don't need a union. And that is a byproduct of the union movement. and that is even even if an employer is treating their employees well because they're trying to avoid a union, that's fine, as long as you're treating your employees well. You're accomplishing the purpose of the labor movement, and that is having employees being treated well.
And we come in cases where that's not happening, and most of the unions we represent, they very much need a union in their positions. I know I grew up in a union household, and my grandfather was a Teamster, and my dad was a Teamster, and I've seen it for many years, and I'm also very passionate about what we do. But at the end of the day, we have to do a job where, some companies aren't treating their employees correctly, and they need a collective bargaining agreement and a union to ensure that they're following the rules and making sure those hardworking employees are compensated correctly and receiving the benefits they deserve in their work.
And I don't want to give the impression that all employers are evil and they all try to avoid their employees becoming unionized, because that's not really true. Several years ago, I was golfing at my old country club. It doesn't exist anymore. And I was paired up with 3 business owners. I didn't know them, and one of the I told them that I was. They asked me what I did for a living. I told them I was a union lawyer, and and one of them said, "Oh, I own a business that has a contract with Teamsters Local 249," and I told him that was one of my clients, and he said his grandfather started the business, and he started out working as a teenager for the company. He now owned the business, and he's getting ready to retire. And he told the other 2 business owners and me that if he had a choice as to whether it be a unionized company or a non-unionized company, he would be unionized. And he had no reason to tell me. He was getting ready to retire, and he went through a list of all of the union business agents he dealt with over the years. And he said that his company never had a strike. His company did not have an HR director. He said that he negotiated his contracts as they were up for renewal every 3 years. He said that when times were good, he was generous at the bargaining table. When he needed relief, when times were slow, he asked for relief, and the union gave it to him. He said that he never had to fire an employee, that when he had a problem with an employee, he called the union business agent, and that employee got straightened out. He said that he never had a case that went to arbitration. He said when a grievance was filed, if it was a meritorious grievance, he granted it. When it was a bad grievance, he explained it to the union, and they withdrew it. He said that he liked having a union. He never had to deal with multiple employees. He just called the union when there was a problem. That for him, it was a benefit having a union. That was his opinion, and he told these other guys that. So I mean, that's just a perspective. That's not all employers are like that, but that was his perspective.
And employers should realize what unions can do for them, because at the end of the day, it's not all negative. Having happy employees who, and are happy to come to work and do their job at the end of the day. And also, it's nice for some employers, like you said, the man you met golfing, to have kind of a third party to deal with their issues.
But that's not a typical situation, I should say. There are many employers aren't quite so enlightened. And it's also different in the construction industry. I represent some construction industry unions, and it's totally different. Employers in the construction industry are not, their employees are not organized. What happens in the construction industry that they go to the union and sign union contracts, and there are different laws that apply in the construction industry altogether. So it's a totally different situation.
Yeah, absolutely. And I think if you're if you're located here in Pennsylvania and you have you're looking to form a union or you're a business agent within a union, you can always give our law firm a call, and we're happy to talk with you about, your rights and what the best process is for, becoming unionized or something like that. But it's important to, if you're looking to unionize, to reach out to an attorney, kind of become aware of the process, because like Ernie said, it is very complicated. And, become aware of what you need to do, and you can move forward with that process, or at least what you would need to do if you wanted to do it in the future.
Okay, it's been a pleasure talking today about unions, my favorite subject.
Yeah, it was absolutely great getting to talk about unions. Both myself and Ernie love what we do, and we love, empowering the labor movement as much as possible. So if you ever need anything, you can reach out to one of us here at Quatrini Law Group.
Okay, Casey and Ernie, thank you very much for coming in today.
Thank you.
And that was Ernie Orsetti and Casey Seaman, and they are from the Quatrini Law Group. They have an office on East Main Street in Uniontown, as well as an office in Somerset and Greensburg. And you could join them on the first and third Monday of each month at 11:25 here for Quatrini Law Group. Their phone number is 888-534-6016. Again, the phone number 888-534-6016 for the Quatrini Law Group. And they'll be back with us on the first Monday in September. Right now, we have partly sunny skies and 74 on this Monday. We have the news coming up here at the top of the hour. And that, of course, as always, we'll start with CBS News, and then we'll have local, district, and statewide news, as well as the obituaries, the bulletin boards, sports, weather, and more. That's coming up next here on WMBS.
You're listening to WMBS Uniontown. Now, ladies and gentlemen, our national anthem.